right. Good morning, everyone. We've got 12, 13 folks registered coming in. We'll give it a few more minutes, maybe a minute or two, get everybody signed in. Good morning, everyone. Welcome. Just give another minute or two here to get everyone signed in. We'll start momentarily.
Tommy, I would have thought you had some music for us while we're waiting for it to start.
I know I've got to work on that, definitely. Get some background Zoom tracks pre-recorded ready.
I was thinking some live guitar from you, buddy.
I see one in the background there.
I don't know, man. Maybe at the end. We'll see how much time we have.
All right. All right. Well, we'll go ahead and get started as other individuals get signed in. Good morning, everyone. My name is Tommy Dennison. I'm the Director of Member Development here at the Asheville Area Chamber of Commerce. Really excited to bring this webinar to you today. Welcome to Financial and Legal Strategies in the New Normal. Before I introduce our wonderful panelists, just a few housekeeping items. At the bottom of your Zoom screen, you'll see a Q&A button. Please submit all your questions for this event through Q&A, and we'll address those as quickly as possible towards the end of the webinar this morning. And additionally, if we aren't able to get to all the questions in our allotted hour today, I'll be sharing everyone's email address to our panelists here this morning that you can reach out to them individually as well in our chat screen as well. So we did also receive some questions ahead of time. Thank you for submitting those. Our panelists have worked those into their presentations today, and then we'll be addressing them during the webinar as well. So let's introduce our wonderful panelists this morning. Rollin Groseclose is Vice President of Tax Services at Johnson Price Sprinkle. Rollin is responsible for coordinating the firm's tax services for clients, both businesses and individuals. He has significant expertise in the areas of tax and business advisory services and focuses his energies on manufacturing and distribution, construction and real estate development, and hospitality. His expertise is also extensive in purchasing and marketing cooperatives, as well as with clients that have multi-state and international activities. Derek Allen is a leader in the alcohol beverage law, real estate development, and zoning and land use. He has extensive expertise with craft breweries ranging in size from small startups to those with national distribution. His practice includes representation of craft breweries, wineries, and distilleries in a wide range of permitting, regulatory, and trade issues. Jamie Kilbourne is a litigation attorney with 22 years of experience. in all aspects of litigation, including depositions, hearings, mediations, arbitrations, jury trials, and appeals. He primarily handles the firm's complex litigation, construction litigation, and appeals as well. He has significant trial experience in state, federal, and tribal court, and is an excellent strategist and negotiator. Jamie is also a certified mediator. Welcome to all of you this morning. Thank you so much for being here. Jamie, if you want, please start us off here with some background on the policy background on PPP and the EIDL.
Sure. First, Derek and I, and I'm sure that everybody who's presenting on the call likes to give an initial caveat. There are two caveats because we're lawyers. The first is that these situations are changing extremely quickly, and as Derek often says, we're giving this advice at 10:03 on Tuesday, and it may be different by the end of the day. So understand that this is a quickly evolving area of law, and that over time these situations are going to change, and the advice we give today may not be the same advice we give tomorrow because of that evolution. The second thing is that you have accountants and lawyers on this conference, but nothing about this resembles the attorney-client relationship or the accountant-client relationship. We're going to try and give folks general advice about the situation, about what's going on, without actually going into a whole lot of the specifics or the clearing of conflicts and the things that would normally be required for an attorney-client relationship to be created. So understand that the advice we give is general, and we encourage you to talk to your own accountant and your own lawyer to get the specific answers as they apply to you. Derek, is that about all the caveats?
I think that's right. And, kind of a general context for this conversation is that we've seen these general rules come down and these big tools come across, and applying them to specific examples is really what we're doing today. So by this time, folks have seen the general applications, read all the white paper articles, and we're starting to learn from those and use those tools. That said, any questions that you might send to attorneys or accountants are open for today's discussion. They don't have to go into the buckets that we have been seeing already. We're using those really as examples. So if you have questions that belong in the legal or financial world, feel free to fire them in, and we'll use those to learn and how we actually implement these tools in the real world.
And to get back to the idea that I promised you guys. Now, first, let me apologize. I'm sitting here in the mothership at the office. We don't have all of our technical staff and paralegals back, and if we did, we might actually be able to get this camera to do a close-up rather than the entire giant room. So just please forgive the fact, and you probably are actually beneficial that I'm not filling your entire screen. That's probably a benefit to you and your computer system. I want to go through a little history of the PPP because I think it's quite interesting. And when we talk about the history of the PPP, we're talking about the last 6 weeks. And there'll be books written about this someday by people who are much more skilled in this area than I am. But there have been a number of stages as we went through the PPP. The first stage, and I read this particular bill immediately after it was released. And for those of you who remember those crazy days, the Senate passed this bill late one evening. A copy of it was available, I think, about 11 o'clock in the evening. I stayed up all night. Read it, sent a bunch of text messages to my law partners about what this particular bill involved. And what I basically told them is I said, it looks like the government's trying to throw cash out of a helicopter. And that's exactly the way that particular bill was created. The CARES Act was intended in as many ways as possible to get money to people in the midst of what was at the time a newly emerging crisis, and now is become the new normal. But as part of throwing cash out of a helicopter, the way the law was written, there were not a lot of protections to make sure that the money was targeted narrowly. The bill is extraordinarily general. It contains provisions such as the fact that these are non-recourse loans. It contains the requirement that the lack of requirement that individual banks and businesses, typically in an SBA loan, a business will have to find that they cannot go to a general bank, that the SBA is a lender of last resort. That was removed from this law. A lot of the protections and securities that exist in ordinary SBA loans were removed from the law specifically. All those things are being revisited on the administrative side now, that they're no longer interested in throwing cash out of a helicopter. When I first read it, the way it was written, I think they intended in 7 days for $300 billion to be tossed out of banks into small businesses. Obviously, that did not happen that quickly, and it took a good deal longer for the first process, and it's been refunded now, and the second process has not. It still has about 100 billion left. So what they did in this sort of throwing cash out of a helicopter environment was create a very, very loose law that included the right of the LA Lakers and Shake Shack and many publicly traded companies to access this money. At one point, there was discussion that Hilton, the major hotel chain, would actually qualify under the rules as they were written. So in the initial stages, obviously, very quickly designed law that had never seen anything similar done in the United States before. So that cash of a helicopter also included basically drafting rules in about 2 weeks. Those rules were released the night before the funding system went live. The banks were forced to figure out things as they went along, and many banks and many lenders basically did a year's worth or 5 years worth of lending in the course of about 3 weeks. The joke is that during April, there was no such thing as bankers' hours. They were the same as the hours at the 7-Eleven. And they were open 24 hours a day, 7 days a week, trying to pump through these loans. So that was sort of stage two, was the sort of run to catch cash. We all knew that there was not sufficient funds in the original program to handle all the people who wanted to keep folks employed. That was originally the idea, is to provide money for payroll so that folks would not be sent on to unemployment. So there was stage two was sort of a run to go catch cash in the PPP. And that lasted until the cash ran out. And then stage three was trying to figure out where the money went. And two interesting things have happened as a result then in stage three. One was the shaming of public corporations, which has been kind of an interesting aspect. The law was written to allow the LA Lakers and Shake Shack to get their money, Harvard University, but they created a lot of shame, and those folks have now returned that money in large part. Some say they're not going to. But in the process of trying to figure out where the money went, obviously, in this process, we talked to a lot of our restaurant clients and folks who were still closed. The PPP did not work for well at all. You had a funding regime that only lasted 8 weeks. And if you were not going to open until 4 or 5 weeks into the funding process after you'd gotten your loan, there just simply was no way that the forgiveness was going to make sense, and it was just going to add additional debt. So those articles started coming out pretty early on with restaurants saying, this is not the thing that makes sense for us. It's the rules and the way it's written don't help us. So they quickly decided to put more money in the system and put a few restrictions on that money, such as allowing some of it to go to small banks and medium-sized banks. But this stage is what I would call the "we are watching you" stage. Treasury is changing the rules on almost a daily basis as to what qualifies for forgiveness, who qualifies for these loans. They actually changed the rules so much they created what they called a safe harbor, that if you got PPP money and were going to return it by May 14th, that they would look the other way and not investigate you. They threatened to audit everyone who got a PPP loan. They've basically done everything they could to try and discourage folks from taking the money, and it's actually worked. There looks like about $100 billion, $70 billion, and different folks have different numbers. And of course, as the money's being returned by big corporations, that number will actually go up rather than going down. But it looks like it actually worked to the point that they're not going to be able to expend all the money in a reasonable time, at least within the next month, within the first month here of the second process. There was some discussion that in 72 hours, all the money would be gone. And here we are a couple weeks in, and it's basically slowed to a trickle. And that's because people are afraid to get the money. So Treasury's done what they wanted to. They've scared people into not taking the money. They've changed the rules so no one can figure out what's going to go on and whether they'll get forgiveness or not. So they've managed to avoid handing the money out. But this reminds me of, I used to have a professor who worked on the super fund back in the day. And what he would talk about is he'd talk about that they realized there was not enough money to clean up all the toxic waste sites. So working in justice, his number one job was to protect the super funds, not to clean up toxic waste. And Treasury done such a good job of protecting the PPP money that no one's taking it anymore, even folks who might be a good solution for. So that's sort of what we've got at stage 4. We're hoping stage 5 is forgiveness in the end, when we all live happily ever after and move on. I will tell you that there's been a lot of publicity about 2 guys from Rhode Island who made up 4 corporations and took a bunch of PPP money for businesses that didn't actually have employees. Pretty unsophisticated fraud, pretty easy to detect. Just checking the IRS records against the application would have figured that one out. But I imagine there's some really sophisticated fraudsters out there. I imagine there's someone over in the special foreign assets division at Treasury trying to figure out how we make sure that some of this money did not go to fund a terrorist organization to pay their payroll, or go to pay for food in Cuba or something that those foreign asset guys are so concerned about. So there's a lot to be written about this in the end and how it plays out. Senator Johnson from Wisconsin has already written an editorial saying that he wants to change the rules retroactively. If there's one thing businesses need, it's sort of established rules so they can make decisions. And it appears that that's something Congress isn't willing to give in the PPP world right now. But obviously there's been no attempt to change it. There are a number of rules that were adopted originally by the Treasury Department to implement this particular provision. Some of those provisions in the formal rules may not have been contrary to the law, but certainly changed the law in some fundamental ways. And then since then, they've been issuing facts, frequently asked questions, that is administrative guidance on the implementation of the PPP program. Some of the guidance actually is directly contradictory to portions of the law. The Treasury Department may realize this or not, or they may not care. I will tell you, the Department of Justice in 2018 did issue a letter that basically indicated that they would not be prosecuting people who didn't follow agency guidelines that were contrary to laws. So that gives you a little bit of safe haven to pay attention to the law. But that doesn't mean the IRS won't come and audit you. It just means the federal government won't try and put you in jail. So where are we 6 weeks in? Well, as a program to throw cash out of a helicopter, it was not terribly effective. Much like the other programs, much like $1,200 for everybody, it just simply was not enough. It was not focused enough, and it didn't create enough jobs. For restaurants and folks who are not yet open, which is a major part of our tax base here in Asheville, these owners are making decisions that this loan doesn't make sense for them and have never applied. So restaurants are calling for some sort of a different bailout. The story of EIDL, the emergency disaster loans, is pretty similar. They put a bunch of money in emergency disaster loans. Folks applied for them, trying to get through the crisis. They said every business who applied can get $10,000 and we'll send you a check immediately. Number one, they didn't send them a check immediately. And number two, $10,000 went down to 1,000 employee. And for a lot of folks, the difficulty in EIDL was that it was a loan that would be on the books and they'd have trouble paying that back even after the disaster. Because quite frankly, none of us know what's going to happen in April, May, June, July. We don't know if it'll close back down in November, and are we going to have the cash reserves as a restaurant or as a business to be able to survive that? So that's sort of the 10,000-foot historical overview of both EIDL and PPP. There are, I'm sure we're going to talk about a number of state loan programs. There's a number of local efforts that have been made. Basically, our general advice to folks is don't do something stupid, either illegal, immoral, or contrary to your best business principles, trying to chase after a magic grant or a magic loan. Do what you need to do to survive and make those decisions on a day-to-day basis, because all of us are in this thing together and we're all having to make those sort of rash, quick decisions to decide how we deal with today and how we deal with tomorrow. So is that the overview you wanted?
Absolutely. Yeah. Thank you, Jamie. That was wonderful. I appreciate it. Next, let's move to Rollin. You know, we've had a good bit of questions around, PPP come in. But if you could talk a little bit about, maximizing that PPP forgiveness, and then maybe some other helpful recommendations that you have for the audience today.
Great, thanks, Tommy. I have put some slides together and we'll make this available afterwards. There's more here than I can cover, but I wanted to call out a few things that we've gotten a lot of questions about, some misunderstanding of what this program is, how it works, particularly the loan forgiveness aspect. And so I want to spend a little bit of time addressing that, make sure we're on the same page. Jamie addressed a number of these things already, so I won't hit all of these. But I want to mention a couple of things. So the loan, one of the big attractions to this program is that the loans are fully or partially forgivable. And so once people get the money, then they're like, okay, how do I get the maximum forgiven? Is it automatic? What do I need to do? That sort of thing. And one of the features of the program is the first payment doesn't apply for 6 months. So you don't have a payment until 6 months after you get the funds. In the meantime, you've got an 8-week period, which is obviously shorter than 6 months, when you have to spend the money a certain way in order to have it forgiven. So there's a gap between the end of that 8-week period and the first payment that's due, so that you know what's really left, what's left that's not forgiven that I would have to pay back, either over the regular course of the loan, remaining 18 months, or just pay it all back at once because I don't need it, whatever the case may be. I will say, our perspective is, my perspective anyway, is maybe a little bit more positive on this program, is that while clearly it missed the mark in a lot of places, in a number of businesses that we've seen that we work with, it has seemed to fill a void. It's provided some liquidity, it's provided some cash for uncertain times. And one of the key certifications of this program that business owners had to sign off on was that there is substantial economic uncertainty, and that's why getting this loan is necessary. And so we have seen this meet the needs of quite a few businesses. There are certainly those, especially in the Asheville areas, we look at tourism, the hotel industry, and the restaurant industry in particular. Getting this money early is maybe a question mark. If you haven't applied yet, and since there are quite a few funds left, maybe you want to sit on that decision a little bit longer and see, maybe this is still a viable program. Maybe we get more guidance. I looked this morning, and as of Monday, SBA had reported that there's about 45% of this second round of funding that's still available. So the second round was about $350 million, and about 189 has already been deployed. So there's quite a bit sitting out there. This second round is going out slower, but it might still make sense for a business to consider this. Maybe as we come out a little bit, maybe the curve has flattened and we start seeing a little bit into the future what things might look like. The loans have to be made by June 30 as the law is currently written, but that means there is a little bit of time still. You just don't want to wait too late if this is a good fit for your business. 1 second here. So I want to address just briefly, Jamie touched on this. I mentioned the economic uncertainty. That's a certification that the owner of the business had to sign off on, saying there is economic uncertainty. And that uncertainty has to make the loan necessary. That's the language that was used on the loan application. But the question that's surfaced because of this pressure that Treasury has put on some of these bigger entities or more visible entities like the Lakers and Ruth's Chris, did they exhaust their other sources of money? Is this really necessary? And that's something that we didn't really have an understanding of. There was no indication that this was a need-based loan in the law, but that's how SBA interpreted this. One of the things that Treasury Secretary Mnuchin has indicated is that they plan to audit all loans that have been made over $2 million. That might seem like a lot, but believe it or not, we've seen a number of those here in Western North Carolina. Companies that are under 500 employees, and because of the volume that they spend in payroll, they've had loans in excess of $2 million. Some of them, just because of that plan to audit everyone, what Mnuchin said, have decided maybe this isn't for us. We don't want them coming in looking around. We were eligible, we applied, we think we were eligible based on the criteria, we just don't want to mess with it. So that's some of the uncertainty that's coming with these. So again, I'm going to try to focus on a few details because I think some of these details, we see questions around these details on a regular basis. The primary use of the funds has to be for payroll. As Jamie mentioned, I view this as a counterpart to the unemployment system. Rather than sending workers to the unemployment lines, we'll give money to the employers to keep people employed. That's a big part of what this program was for. And so payroll costs represent the majority of what the funds should be spent on. Gross payroll up to $100,000 annually. So you have to back that into like an 8-week period, 15,000 roughly, of money that can be spent. People making over $100,000, that the government doesn't want to subsidize those salaries. So it's just salaries up to $100,000. For self-employed owners, if you have a self-employed business, it's viewed a little differently. You might not have payroll. It might be just you. You might not have anybody else working with you. And then in that case, you actually look at what were your average 2019 profits. And that's how much, that's what counts as payroll costs. Again, up to $100,000. Payments for group health benefits. Again, some exclusion for self-employed owners. We're not sure why. This was in one of the, I think in the interim final rules. SBA said, yes, group health benefits count, but except for the owners. And this was specifically in self-employed guidance. We're not sure why that's the case. As far as we know, there's no such exclusion for any other businesses like an S corporation or a corporation that's paying group health benefits, including the owners, because there's nothing about that in the law. This is SBA's interpretation. Payment for retirement benefits, and then state and local taxes, which for North Carolina, that's generally just state unemployment tax. No other payroll taxes are counted in this. You're not supposed to use the PPP funds to pay your Social Security or Medicare match or any of that. It's not supposed to be come from those monies. And then I think we established this pretty early on, doesn't include payments to independent contractors. These do need to be employees. So just a bit of a visual, because we've had a lot of misunderstanding around what loan forgiveness is. So the most that you can have forgiven, I think this is obvious, is the amount of the loan itself. You're not going to get some extra money on the back of this. The maximum amount you can have forgiven is the loan amount. But actually we have to narrow that down to what do you actually spend in the 8 weeks after you get the loan. So that could be a smaller number. You might not spend the full loan amount in the 8-week period. The maximum then you can have forgiven is what you spend on qualifying costs during that 8 weeks. Then we have a couple of more things that could reduce how much you can get forgiven. We have to look at full-time equivalent headcount. I'll touch on that in just a minute, but the headcount is relevant and is important as well. And then you could also have a reduction if you've decreased people's pay by more than 25%. So you start at that big kind of red circle there, the total loan amount. You might have a much smaller amount that can actually be forgiven. And then you have a couple of choices. You just either let that term out to a regular loan, maybe because of uncertainty. It's only a 1% interest rate. That's the rate that they're applying right now. That might make sense. Or you might just decide, I don't need this or I don't want this, and you just pay the balance back that's not forgiven. You probably will have some interest to pay for the amount that's not forgiven that accrued during that 8 weeks, because the interest does start accruing from day one. You just don't have to pay anything until 6 months out. So the 8-week period, this is really critical. Again, what you spend during the first 8 weeks after you get the money is what can qualify for forgiveness. At least 75% of those monies have to be for payroll costs. I'll try to get to an example in just a minute, because I think working through an example might be helpful. And then there are some additional overhead type costs that can also qualify. And so if at least 75% has to be for payroll, that means these can't be more than 25%. So 25% of the funds, the maximum is the maximum that you can spend. So if you had mortgage in place before February 15, that's real or personal property mortgage, the interest can count. If you had a rent agreement in place before February 15, then the rent payments can qualify. That doesn't say real or personal property in that case, so we assume it's both. They didn't really indicate in that case like they did in mortgage. And then utilities, pretty obvious what utilities are for the most part, and they specifically mentioned telephone and internet. They also, in one of the SBA's guidance, referred to transportation utilities using the term vehicle fuel or business vehicle fuel. So if you are accustomed to paying fuel for business vehicles, transportation vehicles, trucks, those sorts of things, evidently those are counted as utilities for this purpose as well. And I mentioned a couple of reductions that can happen. Not going to have time to get into the details of this, but I just want to call your attention to them. If you have a reduction in your full-time equivalent head count during this 8-week period as compared to a base period, again, too complicated to cover, but just be aware that the total amount that you spend might not be forgivable if your head count is reduced during these 8 weeks. Also, if you reduce anybody's pay by more than 25%, these two reductions can actually be cured by June 30th. One example is if your head count, reduction in head count is costing you some additional forgiveness, your forgiveness amount is being reduced, then you can correct that by June 30th by hiring back, either hiring the same people that you had to lay off before, or by hiring replacement people and getting your full-time equivalent head count back up. I'll leave that last bullet, I'll mention that just because there are uncertainties. We don't know exactly all the details about this. We just have basically what's been written in the law with little guidance beyond that. So that's the extent of what we can base it on right now. So I want to run through this example. I hope this will be helpful. $100,000 loan. Let's say during the 8-week period that you spend $80,000. So 55 on payroll, 25 on these other allowable expenses. And let's say that your full-time equivalent head count is at 10, averages out to 10 during this 8-week period. Before that, a base period we have to look at, let's say it was 15. So what's eligible for forgiveness? So we had first a $100,000 loan, we're not going to get the full amount forgiven. We only spent $80,000, so that's the maximum at this point that can be forgiven is $80,000. But then because we spent really disproportionately too much on these other costs, not on payroll, we have to limit the amount of forgiveness based on that $55,000 we spent on payroll. So I took $55,000 divided by 75%. That's the maximum or the minimum that has to be spent on payroll. That gives me a number of $73,333. That's the maximum at this stage that can be forgiven out of a $100,000 loan. Then, because our head count was reduced, I'm assuming that this was not fixed by June 30th, then we're basically 10 out of 15, 10 divided by 15 is about 67%. So then that 73,000 is whittled down even further, down to about $49,000 of actual loan forgiveness. So 100 minus 49, that leaves $51,000 that's going to be a loan that's going to stay on the books unless we just decide to repay it. That one's going to have standard terms that start 6 months after you receive the loan. It's a 2-year loan, so presumably at that point you've got 18 months left on the loan. So that's just a quick example of how a $100,000 total loan might not be totally forgivable and how it can be whittled down. And of course, this is all facts and circumstances, case by case, that you have to look at your own situation. I want to address just a few points on the unknowns. And I've mentioned this not to complicate things, but because there are questions, these are the kinds of questions that we're getting. The law refers to costs incurred and payments made during the 8-week period. We're not sure exactly what is meant by cost incurred and payments made. Payments made we get. Costs incurred, what if 2 weeks into the 8-week period, I pay my first payroll, but I pay my payroll monthly. So 2 weeks comes from before the 8 weeks period and 2 weeks is during the 8-week period. Do I get to count it all because I paid it all? That's an unknown, and we don't have guidance on that. Same on the back end. We could have some things that are, essentially prepaid. We don't really know for sure what that means. I think we're going to have to kind of look at the spirit of the law and try to match that until we get guidance. Can you pay bonuses during this 8-week period? I would say it depends. If you have a history of paying bonuses, maybe monthly or quarterly, and the 8 weeks falls during the times that you would normally pay bonuses, then they could probably count. If you're trying to put a full year's worth of bonuses in that 8 weeks and you're not typically paying bonuses during that period, maybe not. We know that we have a cap of $15,000, roughly $15,385 of compensation for an 8-week period. That's $100,000 boiled down into 8 weeks, $15,385. So clearly any amount over that for any given individual won't count. Can you increase pay temporarily? I would say that that's risky. Clearly you're trying to just put some extra pay into the 8-week period when before and after the people aren't normally paid that rate. That would seem like an abuse of the spirit of the law or the intent of the law. What about contributing to a profit sharing plan? Maybe you have a regular 401k match and you've suspended matches, or you've continued matches, but you have a profit sharing component. Once a year, maybe even quarterly, you can volunteer to put in additional money based on company results or profitability. Again, I'd say maybe 8 weeks worth you could pay in that. Maybe you're accustomed to always paying it in May or June during your 8-week period. Maybe it can count. Unfortunately, we don't know for sure what's counted there. What's a full-time equivalent? We don't really know. Some parts of the CARES Act actually refer to a section of the existing law that uses a 30-hour mark. So 30 hours and above would be full-time. But in this case, we weren't given a definition of what is a full-time equivalent. But conceptually, this means 2 part-timers could add up to 1 full-time equivalent. Or it might take 3 or 4 part-timers to add up to 1 full-time equivalent, depending on the hours that they use to define that term. Again, an unknown. What about after the loan is forgiven? Can I use the money for anything else? Do I have to always stick with payroll, utilities, mortgage interest, and rent? The law, as I read it, says those restrictions are only through June 30th. So if the loan terms out, you haven't had it fully forgiven, you haven't spent all the money, and there's some left, it seems to me that the law says you can use it for any other business purpose, that the restriction applies through June 30th. But some of the language in the SBA promissory notes suggests that maybe those restrictions apply, period. So those are a few of the questions that we've heard about, that we've heard from clients and businesses that are struggling to understand loan forgiveness. Tommy, how am I doing on time? Should I go through?
Doing great. Rollin, we actually had a couple questions come in during your presentation that I think are really pertinent. So for the utilities piece, can cell phones be included in that, or is it landlines only?
So we don't have a definition there. I don't recall, and Derek or Jamie, you're welcome to chime in if you saw this in any of the SBA guidance. I don't recall that being addressed specifically, but they did mention telephone. So I can't imagine that they would exclude cell phones, given how prevalent they are and many landlines not even in place. Conceptually, that would seem to apply from what I've read.
Gotcha, thank you. And second question, is the interest limited to mortgages, or can interest on other loans be included? Second part of that question is, what is the determination of a mortgage secured by a deed of trust?
So interesting question. So a couple of tricky things in the law that really aren't very clear to me. It indicates that the PPP loan funds can be used for any business interest. So any interest spent on business loans, but for forgiveness purposes, it specifically uses the word mortgage interest. And mortgage interest they give some definitions there, but in principle, it means that there is real estate or personal property like equipment or vehicles that's securing the loan. There's collateral there related to those loans. So it's not, in that case, for purposes of forgiveness, it's only mortgage interest, and that is on real or personal property. So if you got a deed of trust that's tied up as part of that mortgage, that would be a mortgage interest, or part of that loan, that's a mortgage interest. And that would count if paid during that 8-week period. And if that mortgage was existing before February 15. The idea is they don't want you to go borrow new money just to try to flush some additional PPP loan funds out. So the loan had to be in place before February 15.
Excellent, thank you. Got a couple more here. Okay, so third part to that question is how about a UCC filing securing debt? Would that qualify for the note piece?
So I might get the attorneys to help me out here, but a UCC filing would be for personal property, right? Tied up as part of the loan. Presumably that would sound to me like a mortgage of personal property per se. Derek, help me out there.
Yeah, well, and I think that the bigger parts here are illustrated by these specific questions. And, that's kind of what I want to pop in, because we've been doing a lot of this in terms of applying it. And, you hit it on it when you said, is it allowed and is it forgivable? Because those are two very different things that you have to understand. The allowable piece is, business expenses that would be allowed under any existing SBA 7A loan. That's how those monies get treated. The caveat I would give is, you need to make sure that you're doing a couple of things. One is meticulous accounting of these specific funds, because as these things become more clear and the feds give us more direction on what is or isn't allowed, because Rollin's making arguments that we would make to say, yes, this is allowed, but it's easier to pick off the ones that we know are certainly allowed in terms of the forgiven piece. And so meticulous accounting, and the other big piece is, don't do things that you wouldn't otherwise do. You now have an additional tool, but you don't need to make unwise business decisions in order to qualify for forgiveness if that expense doesn't make any sense. So for these ones that you're doing, knock off the easy ones first in terms of the application. Get with your accountant or your professional advisors to see which ones are going to be in those gray areas, and just keep an eye on that. And if we need to reclassify things as you go forward, if you have meticulous accounting principles and you have the money segregated, that you can do that at that time.
Good point.
Okay, great, thank you.
Rollin, one thing that we need to make sure people heard was you said repeatedly, and I would say the same thing almost every time you did, which is we don't know. And then the second thing we keep saying is there's nothing about it in the law, but Treasury seems to think this is something that's important. And this is something both lawyers and accountants really hate, which is not actually knowing the answer, because quite frankly, the rules haven't been written yet on forgiveness.
Mm-hmm.
Well, and Jamie brings up a good point. And I saw a question come across about personal guarantees on a PPP. And Rollin alluded to this, or didn't allude to it, he said it, and that is these documents that are coming through that are supporting these SBA supported loans on the PPP. The documents don't match up to what I understand the rules to be, or even what the FAQs are coming from the feds, or even what the actual legislation says. And so to require a personal guarantee on a PPP loan makes no sense. And we've seen cross-collateralization documents coming through for PPP loans. Again, that makes no sense to me, but they're in the documents. And what's a borrower going to do right now except for sign those documents? So I'm saying lots of documents that are non-conforming to the rules as I understand them, and there's got to be clarification that comes down the pipe later on. Again, that points to making sure that you understand what you're doing, knowing where that money's coming from, and really going out of your way to show that you did the best that you could with the tools you have right now to account for it, to spend it within the letter, and maybe more importantly, the intent of the legislation. That's what's going to save you, a year from now, 2 years from now, because folks will get investigated. Maybe not folks in this call, but folks will get investigated. And the easier story is to document that you were applying the funds as best you could with the laws that you knew and the rules that you knew and the documents that you had at hand, and did so with the intent in mind. Then you're probably going to be in good shape.
Excellent. Thank you, Derek. And those are great points and great questions coming in too, y'all. Keep them coming. So Rollin, we've got one here based on your point about the incentive piece. What about an incentive premium based on hours worked during previous payroll period if you do not quit? This is a bonus directly related to working with the public during the crisis.
So, I would say first, we're not sure. It's possible that would count. For example, I've had businesses ask me, I'm going to have to bump up my pay in order just to get people to come back to work because they're potentially making more in unemployment than they're typically paid by the employer. Up to $950 a week, which translates to close to $50,000 a year. And that would be more than some employees get paid. So is it reasonable for, a higher pay rate to be used just to get people back in? It might be, and it might be just a business decision that needs to be made. You might have to make that from a business decision. I would say if you decide to go down that track, document that decision, document the why, what you're seeing or what you're hearing from competitors or hearing from others that they're having to pay to get people to feel comfortable coming back to work, the money that you're having to spend, how much you're having to pay them. Telework is certainly great if it's available, but obviously some businesses require physical presence. You can't physically get the work done without being there. So telework might not be an option, but that's a possibility, but it's definitely an unknown area as well.
Okay, thank you.
I want to mention just one thing, Tommy, here. I've given a list of recommendations here, and these are, again, just my recommendations, just suggestions. And they're I think they're pretty self-evident why we've got those there, except for the last one. This one is I'm not making this recommendation for everybody, and I'll put this out there as a question mark, mainly because this might be something to consider for certain businesses that are out there. And May 14 is important because this is when the date that Treasury has indicated, if you decided that you shouldn't have gotten this loan, or you want to kind of just change your mind. I didn't need this loan, or I didn't want this after all, or it's just not worth it, whatever. Repay it by May 14 and we'll forget that it happened. And the only reason I mention that is not because of the fear factor, but the primary one is this employee retention credit. We had a question come in ahead of time about this credit. And one of the conditions on this credit is you can't have received a PPP loan. And SBA has clarified that if you repay the funds by this repayment date of May 14, then it's like the loan never happened. Obviously, you can't have gone and spent all the money or spent the money, but if you haven't spent the money, just repay the loan by May 14, and then it's like it never happened. And what that does is that qualifies you to consider the terms of this employee retention credit. And I put the terms up there. I mentioned this. You have to have been forced to minimize or completely shut down. That might not be a specific business like a restaurant, but because of the general parameters or requirements that the governor or the county came up with, it said these are the restrictions, you were just unable to operate at full capacity, either forced to shut down or just didn't make sense to stay open, or you've lost more than 50% of your revenues, and your revenues are way off from what they were in 2019. I mentioned this because this could be more meaningful for you. You might not know, you might have a lot of uncertainty about loan forgiveness. Maybe you don't think that you're going to be able to have most of your PPP funds spent within those 8 weeks. Maybe you expect there to be a longer term impact well beyond 8 weeks, maybe beyond 6 months, with significant unknowns. This employee retention credit, that's what ERC stands for there, lasts through the end of the year. And it's up to $5,000 per employee when you have these conditions. You've been forced to kind of limit your operations, or your revenues continue to be significantly off what they were previously. This could be money in your pocket that's maybe a better deal, maybe less scrutiny, less risk and uncertainty than the PPP loan has. So that's a consideration. I wanted to mention that because we're only 2 days away from that date. And we don't have much time left for that kind of consideration, but that's something to work through, to think through, get with your attorney, get with your accountant, and discuss that as a possible consideration.
No, that's great. Thank you, Rollin. Great point for sure. I'd like to pose a question to the group. With the 75-25 spending rules for reimbursement, is the 75-25% of your total loan or 75-25% of what you actually spend? So for example, if I can't open within the 8-week window and spend zero on payroll, but I use some of the money for rent and utility, could I still qualify for partial forgiveness if I don't spend more than 25% of my total loan on rent? I would just then return the rest of the money that I wasn't able to spend.
So I'll comment on this, just kind of going back to this example. You have to have at least 75% spent on payroll. If you spend zero on payroll, then zero is forgiven. And that's pretty clear, I think, in the SBA guidance, at least 75% on payroll. And basically only to the extent that you spend it on payroll will anything be forgiven. And so it's tied really more to what you spend on payroll than the other way around. The rest of those costs are kind of additional gimmies. We had that extra half month in the loan application, so it's 2.5 months. That extra half a month basically came into play to cover this kind of overhead costs. But if you don't have any payroll, then you're not going to get any forgiveness. And if only to the extent that you have some payroll can there be any forgiveness.
Okay, great. Thank you.
That was actually a question that could be answered.
Yes.
Good point. We have an answer for, and we don't have to hem and haw. And Rollin was right on. I mean, you've got to have payroll for payroll protection to work.
Mm-hmm.
Yeah, I would say 2 or 3 weeks ago, though, it was hard to answer that question because we didn't have any guidance yet. And the way the loan docs were written, it looked like you would have to spend all of the money before you could have any of it forgiven.
Good point.
Yeah, thank you. Another question from the audience regarding the ERC. So the ERC, is that employees retained during shutdown or employees retained by the end of the year?
So the main stipulation has to do with the reduction in revenue. So they don't have much in the way of a time frame tied to partial or full shutdown. The time constraints tie more to the revenue reduction. So you could pick either or. If by some crazy stretch you continue to be under restrictions by the fall or by the end of the year, then that should continue to qualify you for this employee retention credit to the extent that you are continuing to maintain employees. It's a 50% credit. So only up to $10,000 of wages count. So let's say you pay somebody $10,000 after a quarter or two, then you've maxed out on the credit. It's a $5,000 maximum credit. So you're not going to, it's not an indefinite period that you keep counting the same employee's wages. So it's probably unlikely that you're going to go all the way to the end of the year with the same employee and continuing to benefit from this credit. After you hit $10,000 of pay for that person, you've maxed out on what you can get under this credit. But it's $5,000 of actual cash in your pocket. It's used first to reduce your payroll taxes. And then if you don't have enough payroll taxes, it's actually refundable, which means you can fill out a form. Off the top of my head, I'm thinking it's $7,200. You can fill out a form and apply for that money to be refunded to you, to actually send a check to you for that excess that you couldn't recover in reducing your payroll taxes.
Okay, excellent. Thank you, Rollin. Jamie or Derek, anything to add with that one?
Nothing here.
All right. Okay, next question. How does the EIDL, grant or loan, affect using the ERC, employee retention credit piece?
So there's no direct tie-in there. Since the EIDL is truly a loan, then there's no impact on this employee retention credit. The only stipulation there was the PPP loan, that if you have a PPP loan. One thing that does sort of tie in more to the PPP loan is that if you have that $10,000 grant or advance, as it's called, from the EIDL, In fact, you can get those without even getting the loan. You can just purely get the $10,000 or up to $10,000 as an advance or called a grant. That reduces your loan forgiveness on the PPP. So if you have both, they automatically take $10,000 off of how much you can get forgiven under the PPP, because they're trying to avoid a double dip, a double benefit there. But the EIDL, I haven't seen any direct correlation to this employee retention credit.
Following up what Rollin just said, reminded me of something on the PPP monies that are taken away from PPP forgiveness, and that EIDL grant being one of those buckets. There are other grants and funds that are out there. Look at the documents on those, because if you read those and look at the PPP language, you'll see that they're probably counting against each other. Again, trying to spread that money out and not allowing folks to double dip for the same uses.
Mm-hmm. Mm-hmm. Yeah, thank you. So moving to a couple of legal questions. This comes from a tour company here in Asheville. Moving forward, when they are, part of the phase 2 reopen, should they have customers sign a waiver when taking a tour with the company?
We've been going. I'll say we've getting this question a lot as folks are trying to reopen. Folks that have tour businesses, offer tours, even folks that have customers coming on site, and the ones that have waivers, we've been going through and looking at those and offering up additional language consistent with what the state and the county are putting out for guidelines for those who are just now implementing those kinds of waivers or signs. Again, doing the same thing, just providing them with some safe harbor there, because you are going to see you're likely to see pieces on the back end in terms of liability issues of patrons. So you want to try to give as much coverage as you can, and that's likely to be consistency with the guidelines that have been put out by the state and locals.
The short answer is, anytime you ask a lawyer, should I get a waiver? The answer is always yes.
Okay. Thank you.
And that's the danger in this environment, is we don't know what the lawsuits are going to look like if someone gets COVID on your tour. We've never had this kind of environment before, so we don't know what the result might be. So, do everything you can to protect yourself.
Sure. No, great. Thank you. So a couple more questions here. We're rapidly approaching the 11 o'clock hour. Want to get to another legal focused question or unemployment piece. Will the fact that Carolina is an at-will state make any difference on unemployment claims? So for example, if his business does not return to pre-COVID levels of sales, does that give us any protection if we can't rehire back to pre-crisis levels?
I can't think of any reason why. Jamie, Rollin, either of you?
The only thing I can think of is you can fire anyone for any reason that's not a prohibited reason. So if you're firing someone and you're laying them off for cause, like they refuse to come back after an order, that's where it gets touchy. But ultimately, that's only a question of whether or not you pay their unemployment tax. That's not a question of whether or not you can actually fire someone in an employee at will state.
Well, I'll answer the question that wasn't asked, and that we've seen a ton in this food and bev space. So I guess, the retail space, and that is folks getting ready to hire back, or in the process of hiring back, and their employees don't want to come back because they can make more money on unemployment. And so that puts the employer in a kind of a tricky position of telling these folks, hey, you have a job, so you don't qualify for unemployment anymore. And the practical position of keeping up other employees' morale, keeping a trusted employee, so they're kind of stuck in a spot and have to massage that based on the facts. But that's a question we're getting a lot, because especially in the food and bev space, they're making more money on unemployment than especially they would make coming back right now with limited hours.
Mm-hmm.
And it almost becomes a moral question rather than a legal one of your relationship to your employees, because if you want to, you can give them an ultimatum to come back, and if they don't come back, you can report that to employment security and their unemployment goes away. but that's not typically how an employer-employee relationship can be effective in any future world.
Yeah, then you end up on wax exchange.
I'll make one other quick comment related to that is because employers are struggling to get people to come back during some of this time. On the PPP loans, SBA did come out a few days ago and also said, if you make an offer to an employee and they choose, like you laid them off and then you make an offer to bring them back on and they choose not to come back, then that actually still counts for purposes of your loan forgiveness calculation, because you did attempt. You need documentation, you need a written offer, you need something back from them, hopefully at least contemporaneous notes of the conversation if they didn't write you an email or something and deny. Of course, that puts them at risk for their unemployment benefits, but the fact that you tried, made a written offer, tried to hire them, they are going to let you count that for purposes of your loan forgiveness calculation, which is a good answer for businesses.
Yeah, excellent. Thank you, Rollin. So one last question. I know we're over the 11 o'clock hour, but this is a good one. Final question for the day. And as you'll note, everyone here in attendance in the chat room area are wonderful presenters and panelists here. Their emails are there available. I've posted those. So with any additional questions that we didn't tackle today, please feel free to reach out to them. Final question here is that if the 8-week period ends prior to June 30, can SUTA tax be included in the payroll cost for forgiveness since the tax will not be paid until July? So
to that, I give our famous answer, it depends, because the law does say incurred and paid, or incurred and payments made. So generally the focus appears to be on payments made, money spent. So it seems like maybe not. It's unfortunately not clear. They haven't defined that you have to actually incur it and spend it within that 8 weeks. I would say, normally SUTA is a pretty small number. Hopefully your unemployment rate is not very high. If you've already been able to determine the amount and June 30 rolls around, maybe go ahead and stroke the check for state unemployment for that tax, just to avoid any questions. Maybe we'll get guidance, but I would say if you're unsure and that's a meaningful amount, maybe just stroke that check before the day's over on June 30.
The short answer is ask us in June.
Yeah, good point.
Understood. Well, thank you all. Jamie, Rollin, Derek, really appreciate your time today. Everyone, thank you for attending. Again, please feel free to reach out to myself, our panelists today. I'm happy to get you all to the appropriate person for those additional questions if we didn't address them this morning. But thank you all again. Really appreciate your time, and hope you all have a great rest of your day.
Thanks again, Tommy.
Yeah, thank you all.